Hello, everyone, and thank you for joining us. My name is Samantha Johnson, and I am the Assistant Director of Alumni Engagement at the University of Colorado Boulder's Leeds School of Business. Leeds is a top business school offering undergraduate, MBA, MS, and PhD programs and has an alumni network of over 41,000 strong living and working around the world. We're excited to have Amy Hartman presenting on myths and best practices on employment law for startups and small businesses for today's webinar. A few housekeeping items before we begin. First, if you have any questions now or during the presentation that you would like to ask, please send those questions through your chat interface. I will monitor questions as they are submitted, and they will be answered throughout the presentation. As a reminder for optimum audio quality, we do have everyone on mute except for myself and our speaker. If you experience any technical difficulties during the webinar, please notify us through the chat interface and one of our support specialists will touch base. Lastly, a link to access the webinar recording will be sent to all registrants later today along with a survey link. Now, I'd like to introduce today's speaker, Amy Hartman. Amy has been practicing in the field of labor and employment law for her entire legal career. Prior to starting Hartman Employment Law Practice, LLC, she was a partner at the Cooley office in Colorado and Seyfarth Shaw in Chicago. Amy has extensive litigation experience in all aspects of the employment relationship, including claims of harassment, discrimination, and wrongful termination, as well as non-solicitation, non-competition disputes arising from executive departures. Amy's practice includes a significant focus on counseling companies on employment matters related to emerging companies, financing, mergers, acquisitions, restructuring, and other transactions, and drafting documentation related to these transactions. Amy provides interactive training for managers and employees on preventing harassment in the workplace and a wide variety of workplace law issues. Amy also conducts ongoing seminars for human resources professionals on such diverse topics as ADA and FMLA compliance, blogging and the right to privacy in the workplace, and telecommuting and other virtual workplace issues. Welcome, Amy, and thank you so much for being here.
Thank you for joining me. The first thing that I want to say is that oftentimes when we think about startups or entrepreneurs, we think that we are too small to be for the laws of the United States and for the laws of the state of Colorado to apply to a startup. And so that is the first myth that we're going to deal with, is that there is, in fact, a multitude of employment laws that apply to businesses no matter what size they are. And so the first thing that we want to understand is that regardless of the size of the employer in the state of Colorado, it only takes one employee to be governed by laws such as the Colorado Anti-Discrimination Act, the state wage and hour law, and other laws regulating how we have to behave towards our employees in the workplace. And the same thing is true for federal employment laws. Depending on the law, the minimum number of employees for those laws to apply is either 15 or 20. And I want to avoid trying to get into the alphabet soup of employment laws, but for example, we have the Age Discrimination in Employment Act, which covers employees with more than 20 employees. We have the Fair Labor Standards Act, which covers employees with more than one employee, and on with regard to the state and federal employment laws. And so the other thing we talk about in terms of being a small entrepreneur or small startup is the myth that we're all going to be on the same page and we're all going to just treat each other as a family, and I don't have to worry about the various either employment laws or regulations because we all kind of know what it takes to be in a startup. And it's kind of a mistake, is that we'll do that, and it's really what we want to do is we want to have best practices right from the get-go, and it's not cost it's not costly, and it's not very complicated to have good practices in place, as we'll see further on in the presentation, that there aren't a whole lot of requirements when you have employees in order to get these things right in terms of how to set expectations and how to treat one another in the workplace. The thing about having the employment laws apply to any size employer, whether or not you have one employee or more than one employees, a lot of times people will then come back to me and say, well, gee, that's exactly why I don't want to have employees when I first start my company. I'm just going to make everybody an independent contractor, and then once I get larger, I'll convert people to employees, or I will sort of start paying attention to the employment laws that are in place in the state or in the federal system. And that really leads us to myth number 2, which is the fact that we can decide whether or not individuals who work with us should be classified as employees or independent contractors. And this is probably something that I could spend literally the entire presentation working on or talking about, is whether or not we have properly classified our workforce as employees or independent contractors. So this is something that companies often make the mistake. The first thing that I am here to tell you is that it is absolutely not a choice that an employer can make as to whether or not they want to classify an individual providing services to them as an employee versus an independent contractor. We start with the premise that every individual that is providing services to a company, startup, no matter sort of the size, the shape, that they start out as an employee. That is the presumption in both Colorado, any other state law, and in the federal system. It's not something that's a choice that we can make. The presumption of employee is presumed, and what we need to do if we're going to try and classify somebody as an independent contractor is to satisfy the various tests that are out there that determine whether or not somebody is an independent contractor. And the biggest test that we have, or sort of the overarching test, is whether or not the employer is exercising judgment and right of control over the individual. So for example, if you are providing the individual with a place to work, you're providing the individual with a business title, with business cards, with a computer. You are directing how that individual is to perform the tasks for you, when those tasks are due. All of those things are indicia that the individual is an employee and not an independent contractor. And some of you may be aware of, there was a recent decision in the California Supreme Court that's getting a lot of attention, that they are using something called the ABC test. The ABC test discusses a lot of the things in the other tests, which is whether the duties are essential to the business, whether the worker is free from control and direction of the hirer with regard to the performance of their work, where the work is performed, and whether the worker is independently performing the same type of work, either for their own clients or for another company. And so when we look at those things, and when we look at the Supreme Court decision, we realize that for most of us, the people that we are classifying as independent contractors are core to our business under the ABC test, or we are exerting a significant amount of direction and control over those individuals, which makes them an independent, which makes them an employee and not an independent contractor. For example, with regard to a company that we're all familiar with, which is Uber, the reason that Uber is running into difficulties with regard to their drivers is Uber made the argument that all we are is a technology play. We're a technology platform that is putting drivers in touch with customers who need a ride. And so Uber tried to make the argument that all they were was a technology platform. When you delve down into it, what the California court said is, well, you can't have Uber without having drivers. So the drivers are actually core to your business. So they can't possibly be independent contractors. And that's sort of the argument that's going on in California. And under the other right of control tests that we have, again, we see that for the most part, the individuals that we choose to classify as independent contractors, or that come to us and tell us that they want to be independent contractors, don't actually satisfy the independence that is needed for an independent contractor. So what does that mean? What that means in terms of getting it wrong? What it means in terms of getting it wrong is if there is an audit, either an individual comes to us later and says, gee, I wish I had been properly classified as an employee. I would have gotten my Social Security taken out. I would have been paying into unemployment, into workers' compensation. I would have gotten these other benefits. The state or federal agency can come back and declare that they were improperly classified and should have been classified as an employee. And so that becomes an issue for us the larger that we grow as an organization, or as an entity. The second issue is that those individuals who were improperly classified as independent contractors, if they're reclassified as employees, may also claim that they are owed a significant amount of overtime, which of course we were not keeping track of. And so the issue with employee versus independent contractor is important to get right from the get-go. Now, again, a lot of people will say, well, I know that in our industry or in our community, many of my, co-entrepreneurs or people in that community have classified individuals as independent contractors, and they, have no problem with that. And so that's an industry standard or an industry practice. And that may very well be, but the reality is that just because, sort of your entrepreneur down the street or in another state is doing it that way does not mean that they are doing it correctly. And it is up to you as an individual employer to decide whether or not you're going to take the associated risks with classifying people as independent contractors versus employees. The other issue that I hear a lot of times is that we want to do some sort of a try to buy. So I want to, for example, test out this work relationship and see if this is going to work. So I'm going to put the person on as an independent contractor for 30, 60, 90 days. And if it all goes well, I will convert them to an employee status. There is no such thing as try to buy under either the state or the federal statutes. And what you're doing in that situation is you're actually creating a worse paper trail, if you will, because what you have is an individual who is going to be under two different classifications with your company, usually in the same calendar year. So you're going to issue them, a 1099 for a certain amount of time, which is the type of status that you give to an individual who you're not taking out any employment taxes, and they're classified as an independent contractor. And then you're going to convert them over to what we call a W-2 employee in the same year. And if there's an audit, the first thing the auditor is going to look at are the individuals who had two separate classifications in the same calendar year. And if they literally are, what we say is if they're sitting in the same chair in front of the same computer doing the same exact thing on day 89, And then on day 91, they sit in the same chair in front of the same computer, and now all of a sudden they're an employee. That creates an issue. They were an employee all along. And so it's something that you really want to be aware of in terms of this issue of independent contractor versus employee. And we may have questions regarding that. I'm having a little trouble with my audio, so if there are questions, we might have to hold those to the end, and I'm just going to move on. So along with this issue of employee versus independent contractor, we also see frequently that we have a workforce that is made up of all salaried, exempt individuals that, and nobody is entitled to overtime in my new startup or in my growing startup organization. And that's another issue that we have, and another myth that we have with regard to wage and hour laws. And so, again, the presumption is that every individual that we employ is entitled to a minimum wage, and they're entitled to overtime pay for hours worked over 40 hours in a work week. And so that is the presumption. And we can get out from under that presumption if we prove that the individuals fall into certain categories of exemption, so certain exempt statuses under the Fair Labor Standards Act. And so the exempt statuses that, the big ones are the executive, so you're supervising 2 or more employees, the administrative, you are engaging, again, in independent discretion, judgment, control for the majority of the time that you're performing your work functions. And 3, the professional exemption, where you have a prolonged course of study. And you have to meet a certain salary basis, which currently is only $455 a week, which is $23,000 a year. It hasn't gone up. And so most people, they meet the salary component of that, but they don't necessarily meet all of the criteria for the other exempt statuses. And so what we have in our startups is a company will come to me and they'll have 20, 30, 40 people, and they'll tell me that the entire workforce is exempt. They have no non-exempt employees. Everybody's paid a salary. Nobody's getting overtime. Nobody's keeping track of their hours. And the skeptic in me usually will say, that's impossible. It's impossible to have everybody being a manager and nobody being managed. And so if you have a workforce that is composed of all exempt employees, you're not keeping track of any hours, you're not paying overtime to a single employee, from the receptionist on up to the chief revenue officer, there's an issue there within your organization that needs to be addressed. The other thing that we come across, which is kind of on the flip side of that, is the inability to pay even sort of a minimum wage, or the inability to pay market rate for a particular position. And so we're either going to defer salary, or we're going to pay in equity instead of salary. And there are some significant issues with regard to either of those situations as well. So let's take the first one, and that is the situation where we want to sort of put on paper that an employee is going to earn, let's say, $80,000 or $75,000, but we don't have the money to pay that salary now. We're going to institute that salary when we get our first widget built, or when we get some Series A financing coming in. But in the meantime, we have an offer letter that says that their salary is 75,000, 80,000, but we're only paying them half that or less than half that. That creates a huge issue of liability with regard to wage and hour laws if we have given an offer letter with a certain salary, but we're not paying that salary. And if the employee terminates, they will have potentially a wage claim that they were not paid the salary that was promised to them. What is the better course of action is to just simply say that here's your current salary, 30,000, 20,000, whatever it is, and you may get an increase in your salary if XYZ happens, but we don't know if that's ever going to happen. And if you're trying to make up for the lack of salary between their initial salary and when the salary increases, do that in the form of some sort of potential bonus. But do not have a salary in an offer letter that is not the actual salary that you are paying to the individual. It creates potential liability that you don't want or that you don't need. It's a headache that you want to try and avoid. The other thing that we often see is that individuals, that companies are going to say, hey, we're just going to pay you in equity. I'm going to pay myself and my 4 other founders in equity. And again, we're not going to draw a salary. That's okay for founders that have more than 20% ownership in the business. It's not okay for anybody below a founder level for a number of reasons. And the more significant one of that is that if you're paying in stock options that you're trying to equate to a certain salary or even to minimum wage, you're in essence potentially creating a valuation for your stock that is well above the sort of cents per share that you probably are issuing your stock options at. And so you're creating a disconnect because you can't value the stock at an artificially high level for it to count towards somebody's compensation, but then go out and say that actually when we're issuing options or shares, it's only 1 cent or 5 cents per share. So you don't want to create an artificial valuation for your stock as a way to avoid paying minimum wage or paying salary. So obviously minimum wages vary from state to state and even from city to city. But at a minimum, you want to be making sure that anyone who's sort of below a founder level is getting paid a minimum wage. And you want to take a look at your workforce and determine whether or not we've got individuals who are being improperly classified as exempt from overtime. Now, they can still get a salary, and we can talk certainly about that well offline, but the issue is that we have to be at least keeping track of their hours so that they're eligible for that overtime pay. So moving on to myth 4, which is the anti-dilution and other equity and pay myths, and we sort of talked about most of those here. You really don't want to be giving away your equity in terms of an artificially sort of price point. And then the other thing that comes up here is sort of the disconnect between sort of founders who are starting up a company and what is going to happen as we go further down the road in terms of further financing. A lot of times the founders will come to me and they'll say, hey, I'm going to be going out for funding from either Series A, venture capital or private equity, or even friends and family. But I want to make sure that I'm going to, stay at 15 or 20% as the CEO and the founder, and I want to put in all these anti-dilution provisions. That's just not going to fly. And so you need to kind of disabuse yourself of the notion that as different investor levels come in, that you as the founder are going to keep retaining that level of ownership that you had at the beginning. And I know it may sound very sort of impractical, in terms of who would think that way, but I can't tell you the number of folks that come to me and ask that we put in anti-dilution language into their employment agreements or into their stock agreements, and I have to sort of try and gently disabuse them of the notion that you're going to stay at that 25, 30% or even 15, 20% ownership as further rounds of funding go on. Typically, we see non-founder CEOs holding anywhere between 4 and 8% of shares, and we see founder CEOs settling in around maybe 8 to 10% of fully diluted shares as further rounds go on. But you're not going to get that anti-dilution language either for yourself or for your core executive team as further rounds come into the company. And so we just want to make sure that people understand that right from the get-go. So next myth is, okay, I sort of jumping around a little bit, is that I've got these employees, I've kind of looked at my workforce, and I listened to Amy Hartman, and now I can't have 30 independent contractors, which is really a bummer. So what does it mean to have employees? What do I have to offer them? And the reality is, and it may come as a surprise to you, not much. So employees of a company, an employer is not required to offer paid vacation. You're not required to have a foosball table in your conference room. You're not required to have a beer keg or a wine bar or any of these other perks that you may hear about from other companies. These are all perquisites that a company may decide to put in place to attract or retain their employees, but for the most part, these are not required. So what are required in terms of actual benefits? Well, if you're over 50 employees, you are required to provide access to health insurance coverage. That access does not mean that you have to copay premiums, for example. You can have it be 100% that the employees are responsible for their healthcare premiums. It can be that you are going to do some sort of a copay, but again, you're not required to pay for health insurance. And if you're under 50 employees, you're not even required to offer health insurance. You're not required to offer any kind of paid leave unless you're in a state that requires a certain number of paid sick leaves. That would be California, New York now, not Colorado still. I can talk probably ad infinitum about the downsides of hiring employees in California from an employer perspective in terms of the regulations that are unique to California. But yes, in terms of the kinds of benefits that you have to offer to employees, that really is up to the individual employer. We're seeing a lot of companies go to flexible vacation schedules or unlimited vacation pay. And I've seen that kind of go both ways in terms of companies' implementation of these unlimited vacation policies, sort of, take vacation, flex time, recharge. It goes by a number of different names. Sometimes employees are skeptical of those types of policies. The company's trying not to pay me. The company is hoping that I'm not going to take vacation. So if you are thinking about going to some sort of flexible or unlimited PTO, paid time off, you want to make sure that you're careful in how you roll that out and how you message that. It's not as easy as you think, and sometimes it's not as welcome as you think. it is certainly a benefit from the company side if you have strong managers that you no longer have to track PTO or accrued PTO, pay, accrue these big balances that then have to be paid out or rolled over. And so there are benefits to the unlimited vacation time, but it has to be done in a way that your employees are comfortable that they are really being encouraged to take vacation and being allowed to take vacation at a reasonable level. So the next myth that we see a lot of is this concept of at-will employment. A lot of times I often hear, well, we're an at-will state, or more accurately, I hear a lot of times that we are a right-to-work state. Just so you can impress your friends after this call, I'll take 2 seconds to explain the difference between right to work and at will. So right to work is actually a concept that comes into play with regard to unions. And a right to work state means that you have the right to go and work even at a unionized company and not pay union dues. So for those of you out there who have been sort of talking with their friends and often talk about Colorado being a right to work state, yes, it is, but it probably has no bearing on your company and your particular situation. What you mean and what your friends mean is Colorado is an at-will employment state. And in fact, 49 out of 50 states in the United States are at-will employment states. The only state, fun fact, that is not an at-will employment state is Montana, where you actually have to supply an employee with a written rationale for the reason that they were being terminated. But all other states are, in fact, at-will employment states. So does at-will really mean that we can do whatever we want and fire people for any reason or no reason? Yes, but there is a big asterisk to that, and that is we can fire people for any reason or no reason as long as we don't terminate people for an unlawful reason. And so at-will does not in any way trump the anti-discrimination laws, whistleblower protection policies, any other law that takes precedent over at-will, that limits the at-will, which is any law that provides protections to employees for speaking out, for being free from discrimination. All of those laws are in concert with at-will employment. So at-will employment does mean that we do not have to give a written reason for an employee's termination. There is no requirement at the state or federal level that we have to provide performance improvement plans or written evaluations or anything along those lines. But at-will does not mean that we can flaunt the other non-discrimination laws or whistleblower laws. And there are, numerous laws that protect employees in the workplace. One that I want to point out that we are seeing more and more of is the use of the Americans with Disabilities Act. And again, Colorado and almost every other state has a corollary anti-discrimination act with regard to disabilities. And so disabilities can be mental disabilities, they can be physical disabilities, it can be extreme anxiety, it can be different types of bipolar disorders. There are a lot of things that an employee can raise with you with regard to needing assistance, needing accommodation, feeling that they're being treated unfairly with regard to workplace rules and regulations. And we can't use at-will employment to say, well, we're going to just terminate you after you've told us about this particular medical condition or this condition with needing to take care of a sick relative or other things. So at-will does not trump all of these federal and state laws that we still have to be mindful of. So I just want to make sure that people understand sort of the limitations that come with at will. So they go in it goes in concert with all of these other discrimination laws that are available and that protect employees from how we behave towards them and treat them in the workplace. The other thing that goes along with this slide and with at will, and I touched upon this a little bit, is what is required in terms of documentation of performance problems or performance deficiencies. A lot of times I'll have somebody come to me and they'll say, well, we're getting a claim from the former employee because we didn't put them on a performance improvement plan, or we didn't give them 3 written warnings on pink paper before we terminated them. Well, that is where at will comes in. We don't have any obligation unless you've created that obligation in your handbook or in any other policy, but we don't have any obligation to provide a certain type of corrective action prior to termination. Is it good to have some documentation of what those performance problems were? Sure. Do I care as an employment litigator what that documentation looks like? Not necessarily. I'm pretty okay with an email communication that can be written in all of 2 minutes that tells an employee, hey, you've been late, 5 times this week, and that has an impact on our business. Why? Because other people are having to do your work for you. And what is the result of that being late 5 times this week is that if you continue to be late, we might have to terminate you. That documentation is certainly fine with me. Hopefully it's not laced with expletives about what a terrible or stupid individual this is. You keep it professional, keep it straightforward. But an email is just as good as something that's written on sort of pink paper and with all the bells and whistles. Any kind of documentation, even a note to the file, a note to yourself, that indicates what the performance issues were, that we had a discussion with the employee, we told the employee what could happen if they continue along this line of behavior, is all fine documentation when we have an at-will employment situation, provided that we haven't put anything else in place with regard to a handbook that sort of undercuts that. So I would say if you did get an off-the-shelf handbook from a website, from a friend, from another company, it's worth it to spin through it and to make sure that what policies you have put in place are the actual policies that are in your handbook. You don't want to disconnect between what's in your handbook that somebody's going to dig out once they're terminated and what your actual practice has been. So coming up now, we have a poll in terms of non-compete clauses that we want to launch now so that we can talk for a few minutes about non-competes in the state of Colorado.
So which of the following statements about non-competes is true? They are not enforceable in Colorado, or they are enforceable only if employee is paid during non-compete time, or they are enforceable in Colorado. So go ahead and select which one you believe to be true. We'll leave it open here for a little bit more time.
And I'll take this opportunity to say, as a reminder, if you have questions, go ahead and type those out so that we can take them either in the remaining time that we have for the few minutes left in the presentation or at the end of the presentation. Either one works for me.
Great, and it looks like we've got everyone has responded here. So Amy, 18% say that non-competes are not enforceable in Colorado, and 82% say that they are enforceable in Colorado. So I'll go ahead and hand it back over to you.
Great. Okay. Well, then I'm so excited that we have a super educated audience because, in fact, non-competes are enforceable in Colorado. We actually have a statute, unlike California, where non-competes are not enforceable pretty much in any way, shape, or form unless it's in connection with the sale of a business, and even those are fairly limited. In Colorado, we have a statute that tells us when we can enforce a non-compete. And the two biggest issues that come up in terms of non-compete enforceability in startups and in technology and life science companies and other companies that we have here in Colorado is, one is for the protection of trade secrets, and two, for professional level or management level employees where it's presumed that they had access to trade secret information during the course and scope of their employment. So two things here that I want to touch on, which is one, when you have employees that are coming over from what could arguably be a competitor, you cannot put your head in the sand and just pretend that you're not going to look at this individual's non-compete or their former proprietary information agreement and just sort of say, oh, well, we just didn't know it was there. You have an obligation, the employee oftentimes has an obligation to share that document with you. And so you just need to understand that if you are hiring away from a competitor, there is every reason to believe that the employee may have a non-compete. That non-compete may be enforceable, and you would just do yourself a favor to understand what the breadth is. Does it apply? Are we taking a risk? What are we going to do if we get a nasty gram, as I call them and as I write them, from the former employer saying, hey, you can't hire this person. They have we have a non-compete. You're a direct competitor. Are we going to drop that person? Are we going to defend it? So lots of issues there with regard to when we're bringing employees over who may or may not have a non-compete. And then, of course, we have the issue of deciding whether or not we want to put a non-compete in place with our employees. We should do that at the beginning of the employment relationship. Continued employment in Colorado is sufficient consideration to support a non-compete. We kind of try to trick you up with that second poll answer, which is a lot of people come to me and say, oh, well, the non-compete isn't valid because I wasn't provided severance. It was a year non-compete. I was only given 2 months of severance. Doesn't matter. Or the non-compete is not valid because I was fired. And I read somewhere that if you were fired, then the non-competes are no longer valid. Also, sort of another sub-myth that isn't true. And so we want to make sure that you understand both whether or not you want to have a non-compete or whether or not you're taking somebody from a competitor and they have a non-compete, just understanding what you're getting yourself into by potentially hiring on that individual. Non-competes and the issue of trade secrets, again, we could spend a whole separate presentation on the issue with regard to protecting our trade secrets and making sure that if we have an employee coming over from a competitor, that they are not coming over and infecting our computer with a whole lot of information from your competitor across the street that we hopefully we didn't ask for, and certainly we weren't aware of. But I have certainly seen some very gnarly situations where the former company traces a lot of their trade secret information through forensic examination, and it ends up on our company's servers, on our company's website. The person downloaded presentations, they downloaded contact lists. It really makes sense to, when we're hiring somebody from a competitor or even somebody in an adjacent space, that we tell these individuals, hey, we love you, we want you for you, we don't want you to be bringing any third-party information with you when you come to work for us. It's definitely, I'm sure, in your confidentiality agreements, but it doesn't hurt to have an extra conversation with somebody who may be coming from a competitor to make sure that they're not going to infect your servers with information that you shouldn't be having. So the next myth is promises. And so a lot of times, again, we get excited, we're in a startup, and we tend to get really excited about what the growth and the potential future of our company is going to look at. And we may say things about the future of the company, and if this goes well, then you're going to have 20% of the company, or you're going to be employed here for life, or you're other promises that we make, either on the back of a napkin or in a bar over sort of a celebration of maybe reaching a certain milestone in the company or getting some funding. And so all of those things that you think, well, that person knew that I wasn't serious when I made that promise, or when I offered them 50% of my company if they would only just kind of finish helping me do this presentation that I need to make 24 hours from now. Yeah, they just knew that I was kidding. They don't. And sort of the reality is that even if they seemed at the time that they were just as drunk as you were, they may not be, and they may have gone home and told their wife or their girlfriend or their husband or their spouse or significant other or their brother-in-law that's a lawyer, hey, great news, when I was at the bar with Ed the other night, he promised me that when we made the sale of the first widget, I was going to get X, Y, and Z. And somebody writes that down, not on a napkin, and brings that up to you when you're going out for your next round of financing, or when you're about to merge with another company. And it can be a very, very costly promise that you made that you did not intend to make, that is now reduced to writing somewhere else, and becomes very costly because it will come up at literally the 23rd hour, and you're going to have to pay that person or sort of negotiate away that situation. So caveats here: never write things on napkins, never have discussions about the future of your company anywhere that alcohol is served. Never tell anyone that you will take care of them, that they have a job for life, their job is secure, or that they can trust you. Do not offer someone a job from out of state if you cannot afford their salary for at least 6 or 12 months. And that's not fair to anyone. And in Colorado, we have a statute against unlawfully inducing somebody into the state of Colorado under sort of false pretenses. So, sort of slightly in jest here, but in all seriousness, you do want to make sure that you're enthusiastic about the growth of your company, but that you're also very careful and cautious about what you're saying in terms of broad and sweeping, generalizations about future employment or the future viability of your enterprise. I can't tell you the number of times where we are on the cusp of a financing or some other event, and we are playing whack-a-mole with former employees and independent contractors and trying to sort of tamp down those claims in order to push through the financing because of something that was said supposedly in jest, but somebody took it seriously and has a lawyer that's willing to run with it. So last thing is, the final myth that I have is kind of along the same lines, is that everyone understands what it takes to work for a startup, and sort of that first breakup, that first employee termination. If you may have an expectation and understanding that what it takes to get your business off the ground, and that is working nights and weekends and working 24/7 and working for very little pay and very little glamour, you've got to communicate that to everybody, to your co-founders, to the employees that you're hiring on. You have to communicate your expectations And people, there's no mind melding in a startup. We don't all look the same. We don't all think the same. And so I can't tell you the number of founders that really just have a painful time when somebody is not meeting their expectations and getting to that first termination. And they come to me and they say, "Gosh, I really thought this person knew what it took, and they're just, they don't want to work 70 hours a week, and I don't know how to, get rid of them, or I've made promises and I can't get rid of them." There's always a way out. We can always part company with somebody, but it's hard, and it's even harder still if you've had no communications, or all the communications are in your head with regard to your disappointment, your frustration with this individual employee. You've got to communicate, and some of us are better at it than others, and a lot of people just come to me, managers, individuals. Well, I just thought that they knew what I expected. They don't know that. People don't know that. They don't know how near and dear this is to your heart. And so you've got to set those expectations, and you've got to communicate, sort of as we said before. It doesn't matter if it's an email or a voicemail or a text message. I don't like text messages. They're too short. But some communication, letting the person know that they are disappointing you, rather than just sort of closing your eyes and hoping that they're either going to resign or go away, or that they're going to sort of sense that you're frustrated with them. A little communication goes a long way to sort of softening the blow when it comes to actually having to do your first cut or your first termination of an employee. And so setting expectations from the get-go is what's really important. So we're almost out of time, and I'm at myth number 9, and you're probably thinking that, like a top 10 list, there's a 10th, but there isn't. There's just 9. And so if we have any questions, I can take those now.
Wonderful. Thank you, Amy. And yes, as a reminder to everyone, you can submit those questions through your chat interface and we'll get them answered. So we do have a question for you, Amy. So if you are in those beginning phases of starting a business, what would you recommend from everything you've talked about today as a priority to focus on first? Where do you start?
I would say the priority is making sure that you have people classified correctly, that you have a good offer letter in place, that you have if you have any kind of technology that you're trying to protect, a good confidentiality, or what we call a proprietary information agreement in place. And that's really the starting point. And we don't really need too many policies. We don't really need too many bells and whistles, but getting a good foundation in terms of making sure that people are classified correctly, and that we've got good documentation around the hiring process is the best place to start.
Great. Yeah, thank you. And another question for you. So, as an HR professional who's working in a smaller business or in that startup environment, what do you recommend is the best way to start having some of these very important questions around these topics with either the co-founders or whoever's leading?
I mean, that's a really great question, and I think that what we often the difficulty we face with regards to the C-suite employee individuals and HR is they see it as a burden that they don't want to get involved in. They don't want to know. It's an impediment to their sort of running at full tilt to get their business started. And so having the answers to those questions, why it's a good practice, why we want to do it this way, how it's not going to, cost us that much more, what are the downsides to not doing it correctly, but I think more importantly, focusing on the positive. Employees expect this. We're gonna attract better candidates. So making it an easy decision for the founder and for that executive team, rather than sort of coming in and saying the sky is falling, I just listened to an hour presentation, we're doing it all wrong kind of thing, is, hey, I learned some things and we should really think about doing it this way. Here's the pros, here's the cons, here's the costs, because that's what they're going to want to know. And sort of, here are some of the myths. We don't have to provide insurance, we don't have to do this, but it's just the better way of doing business.
Yeah, that's so helpful. Thank you. And one more question here before we wrap up today, and this is specifically around independent contractors. So for those independent contractors who have passed the ABC test that you were talking about earlier in your presentation, do you have a recommendation for any resources, like for example, an app that an independent contractor would be able to track and report the hours that they work against requirements and agreed upon statements of the initial work?
I don't have any recommendation for an app, but that is a little disconcerting in terms of, if they are truly an independent contractor, they should be compensated per task. And so if they're keeping track of their hours as an independent contractor and being paid on an hourly rate, that's sort of sending up red flags to me that there's some confusion with regard to the classification.
Okay, so it's very important. Yeah, so what I'm hearing is it's very important in an independent contractor situation to discuss
The
payment
fee,
on a task base as opposed to those hours.
correct.
Okay.
It certainly should be, or if it's going to be paid on an hourly basis, the more that it looks like, hey, 40 hours, or it's like